You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
Rhetoric against federal judges has reached unprecedented levels, with President Trump calling judges incompetent, crooked, USA-hating, and monsters. U.S. Attorney General Pam Bondi calling out individual judges who rule against the administration by name, and the administration filing an extraordinary lawsuit against all the federal district court judges in the state of Maryland. Along with the rhetoric, threats against judges are surging. The U.S. Marshals Service has investigated close to 400 threats against federal judges in the first 5 months of this year alone. A group of more than 40 retired federal judges, appointed by both Republican and Democratic presidents, see this landscape as attempts to intimidate and pressure judges, sway their opinions, and shake the public's trust in the courts. So on Constitution Day, they released an open letter warning that the Constitution and the judiciary is under attack. My guests are two of those judges from the Keep Our Republic's Article 3 coalition. Judge Andre Davis, formerly of the U.S. Court of Appeals for the Fourth Circuit and the District of Maryland, and Judge Paul Michel, formerly of the U.S. Court of Appeals for the Federal Circuit. Thanks so much for joining me. Judge Davis, I'll start with a question to you. Tell us why you and the other retired judges decided to write this letter.
Sitting judges, as you know, are bound by the Code of Judicial Ethics, can speak only through their written opinions and from oral opinions from the bench. And so they are greatly limited, in fact, prohibited, really, from responding to some of the more outrageous and extreme attacks on the judiciary and on individual judges. And so what my friend Judge Michel and his colleague Bob Sindrich decided was that this collection or community, if you will, of retired federal judges at this moment in our history were seeing the same thing, namely an unprecedented and very dangerous attack on the judiciary, on the third branch of government in the United States, and putting at risk not just the rule of law and our democracy as we know it, but the actual lives of judges and their family members. And so that's what prompted us to take what I think is an unprecedented step ourselves by coming together as a group of retired judges appointed by presidents from both parties to speak with one voice and call attention to the danger that is not just implicit, but unavoidable in the kinds of rhetoric that are being used and the direct attacks on the judiciary and the rule of law. And so we're speaking with one voice to, one, educate the public and to speak out in support of our colleagues who work day in and day out to do the people's work in dispensing justice.
Judge Michel, so President Trump has verbally attacked judges who ruled against him. He's called them radical left lunatics, crooked. The U.S. Attorney General Pam Bondi has called out judges by name who ruled against Trump's policies, also calling them similar names. What can you as retired judges do to stop this criticism and this attack that's coming from, the top of the executive branch?
Well, my hope is that if the citizenry can be better educated about the proper function and duties of judges, they will see that the threat to judges is really a threat against their own rights being protected by courts. Courts have to be independent of political pressures, whether from the White House or the Justice Department or elsewhere. And that is what's under attack now. And we think that we have unusual credibility because we're so nonpartisan, non-political, or you could almost say bipartisan, because we have about half our judges appointed by Republican administrations and half by Democratic administrations. And we're enormously diverse personally. But as Judge Davis rightly says, we're completely united in being horrified at the status quo, feeling like this is a moment of grave danger for our country, our democracy, and the rule of law. When you come right down to it, at the end of the day, either the written law is going to control or what the executive wants is going to control. Is it the rule of law or the rule of a king? That's what really is at stake here. And we think that the shrill attacks such as those you cite and quote can be discouraged by the media and the citizenry objecting loudly to that kind of language, whether it's from congresspersons calling for impeachment of a judge simply for doing his or her job and ruling on a case, or coming from the White House or the Justice Department. This is a moment of enormous danger for our country. One of the problems is the citizens have been very much misled. Too many of them are not well versed in understandings of basic constitutional government procedures and structures in our country. So, for example, the most important thing citizens need to realize is the job of a judge is not to promote the agenda of any president or any political party or any other political leader. The job of the judge is strictly to apply the written law, the precedents, and the statutes to the case in front of him. And finally, I think the judiciary is at its most valuable and most important when it serves as a check, just as the founders expected. Checks and balances is the phrase we often use, so that if the executive does something that's unlawful, the judge puts a halt to it, and the courts say that can't continue. So they issue injunctions, and the executive has to stop doing the illegal things, and of course they can continue with all the things that are lawful. So that's really the bottom line here.
So the administration continually runs to the Supreme Court when lower courts hem in its agenda. And on more than a dozen occasions since the new administration came in, the Supreme Court has lifted an injunction issued by a trial judge who had said that the administration was at least probably acting illegally. And sometimes the court offers a few sentences, sometimes nothing. And I'm wondering if that gives the average person a distorted view of what the lower courts are doing in limiting the administration and what the Supreme Court is doing in allowing the administration to move forward.
Well, you've put your finger on something that's very, very, frankly, disheartening about the current legal landscape. The point is that every federal district judge, without exception, who has ruled against some policy of this administration was acting in absolute good faith in his and her attempt to interpret not just statutory law, not just constitutional law, but the Supreme Court's own precedents. That's what the federal district judges around the country have been doing for the last 7 or 8 months. And in those instances, many of them, I would even say most of those instances, where the administration has appealed those adverse decisions by federal district judges, in most instances, the federal appellate courts, of which there are 13, the federal appellate courts have largely left in place the orders of the district judges. So what we see in the so-called shadow docket, I'm sure most of your listeners are familiar with that term by now, is that the Supreme Court is reversing the decisions in large part without explaining how or why those decisions are being reversed. And so that leaves, in the mind of many lay people, this very distorted view somehow that the lower federal courts, the district judges who hear from the parties, hear from the lawyers, consider the evidence, make a ruling, which is then left in place by the intermediate appellate court, and the matter gets up to the Supreme Court. And the Supreme Court, in 1 or 2 sentences, as you say, reverse that decision. Well, a lot of people, on the street, not versed in the law, somehow are persuaded that the lower court judges are somehow against the administration. And as Judge Michel just very poignantly pointed out, all the judges are doing is trying their best to apply the law. And so it disserves justice, in all honesty, to leave in the minds of people that somehow the Supreme Court is protecting this administration from lower court judges. And that just feeds into this misinformation, this distorted view that so many in high office continue to create, that the judiciary is full of lunatics and activists, and nothing could be further from the truth. So hopefully, in the fullness of time, hopefully not too far in the future, this landscape that's been created through the procedural and processes that have been employed will see the light of day. And one of the things that the Article 3 Coalition is trying so desperately to do, to continue to educate people about the role of judges, the role of the judiciary, how the judiciary works, the right to an appeal, and how reasoned judgment is the coin of the realm when it comes to the judiciary.
And Judge Michel, Justice Neil Gorsuch recently admonished lower court judges not to so-called defy the Supreme Court. And Boston federal judge Allison Burroughs said that it was unhelpful and unnecessary to criticize district courts that are working to make sense of Supreme Court orders that are not models of clarity and have left many issues unresolved. And another judge said, I didn't understand that the orders on the emergency docket were precedent. I mean, what about a Supreme Court justice calling out district court judges?
Well, one complexity that the public doesn't understand, but it's rather important, is that nearly all of the injunctions that have been issued by the district judges around the country in these hundreds of suits challenging Trump administration actions are very preliminary. They're actually called preliminary injunctions. And that's because there hasn't yet been a trial. There hasn't yet been a final resolution of disputed facts. So these are truly preliminary in the sense that the district judge is making a prediction, a judgment, that likely the challenger will win over the administration's defense. But it's a speculative judgment. I'm not defensive of the Supreme Court and the extent to which they've intervened, but it is important to recognize that they aren't saying the administration was right and the district judge was wrong. What they're really saying is we don't know for sure yet, so we're going to delay a remedy until there's been actual fact findings and what lawyers call a final judgment. But beyond that, it is certainly true that some of these orders have no reasoning coming down from the Supreme Court. Others are very terse and sometimes unclear. I don't think it's helpful for Judge Burroughs and the Supreme Court justices to get in a public shouting match, in effect, although, of course, they did it in writing. But she has a point. The district judges are striving to apply the law faithfully and impartially. And I think usually they get it right, and particularly where they're upheld, as has been true in a number of these cases, by the Court of Appeals above them, the Supreme Court ought to be very hesitant to jump in and overrule both of the so-called lower courts, as the Constitution calls them, the inferior courts, which is a very unfortunate phrase because they're not inferior. But in terms of the admonition from Judge Gorsuch, I don't know what he's talking about. I don't see any judge, including Judge William Young in Boston, as being defiant, as refusing to follow some clear direction from the Supreme Court. So I'm not quite sure what he's referring to, but it's not very helpful. And it's a further demoralization of the district judges who do 90% of the work in the judicial system and who should be respected and supported by the public and by the rest of the judicial establishment and not pilloried as if they're rebellious children or something, because they're not.
Coming up next, the effect of all those 6-3 Supreme Court decisions on the emergency docket. You're listening to Bloomberg. I've been talking to retired federal judges Andre Davis and Paul Michel about an unprecedented bipartisan statement from more than 40 retired federal judges appointed by 6 different presidents across both parties, speaking out about how the Constitution and the judiciary is under attack. And Judge Davis, I'm wondering about the effect of so many, perhaps most of these Supreme Court emergency decisions coming down 6-3 down partisan lines, especially in this environment where judges are more and more being identified by the party of the president who appointed them, even at the district court level. So you'll hear, well, that judge is a Trump appointee. That judge is a Biden appointee. It seems like people are talking about a judge's political affiliations more than ever before.
I think that's a very regrettable development in our legal ecosystem and in the media. The people apparently want to know that information. And of course, that information is available. One hopes, and frankly, I believe, as a judge appointed by two Democratic presidents, that is, presidents from the Democratic Party, one would like to think that no one would ever imagine when I was an active judge that I made a ruling on the basis of the party identification of the president who appointed me. And frankly, it borders on offensive to individual judges. I can share a very quick anecdote. When I was on the district court early in my tenure, after having been appointed by President Clinton to the federal district court in Baltimore, I struck down the city's affirmative action plan as unconstitutional. And of course, while it was still much rarer then than now, I think the lead in the newspaper was Clinton appointed judge strikes down an affirmative action plan. And I think it might have said a black Clinton appointed judge. Well, I was following the law, and that's what judges do. No judge calls the president who appointed him or her to check in on how the case should come out. It's absurd, it's offensive, but again, you raise a good point. This is the system we seem to be swimming in these days, and I hope that one day soon that will fall out of favor.
Judge Michel, so what can you do as retired judges? What do you plan to do?
Well, we can explain so that the public and the media and community leaders, including the business community and other sectors of our society, have a better understanding and are in a position to fairly evaluate whether the complaints being made by high officials in the White House are accurate or not, and then to call out bad conduct by people who are attacking judges for doing their job. I couldn't agree more with Judge Davis about how hard every one of us tries the minute we take the oath to put behind us our personal opinions, our prior political affiliations, our party registration, our friendships, everything. Becoming a federal judge, it's almost a little bit like becoming a minister or a priest or a rabbi. You're a part of a discipline based on written text, and you swear allegiance to that text. And you have to discipline yourself to not let other considerations enter into your decision making. And my impression, and I've sat with 5 different circuit courts, is that the judges do that very faithfully. I'd say 99% of the time or more, the judges I sat with were not acting at all from a political standpoint, and I often couldn't even remember which party they were appointed under because it just didn't show up in anything that they said or wrote or how they voted. So we've got a real problem in this country if the public continues to have the view that Judge Davis is a Democratic judge and Judge Michel is a Republican judge, because it's totally false. We're judges of the law, not of our political background. And people need to understand that. And really, it's the great strength in the system. It means that every citizen can depend on his or her rights being defended in court by impartial judges, because they can't be pressured by politicians to rule a certain way. They're going to rule based on the settled law, the precedents, as lawyers call them. And that's a great comfort, not only to every citizen in individual rights cases, but also to every corporation. If the corporations can't depend on judges to treat them under the law fairly, they're going to stop taking risks, stop making investments, stop building factories. If they can't count on getting a fair shake from the federal judges, if IRS comes after them or the Securities Exchange Commission or any other arm of the government, they have to be confident that they're not on an enemies list in the White House, that they're going to be treated like any other company or individual by our judges. And the judges do a very good job, in my opinion, and from my experience, at being completely impartial, particularly at every level of the court system, except the Supreme Court, which does look more political to me than the other two levels of the court system.
Judge Davis, Justice Amy Coney Barrett recently downplayed President Trump's criticism of federal judges, saying that U.S. presidents have a long history of criticizing the judiciary. But we talked before about how this administration even went so far as to sue the entire federal bench, all the district court judges in Maryland. Is this administration different in the way it treats federal judges and you know, even the way it appoints federal judges, more looking for more ideologues than for, you know, the what used to be considered, you know, the ABA-approved judges?
This administration, from top to bottom, absolutely treats the federal judiciary in ways that, frankly, no administration before now has ever treated the federal judiciary. The ad hominem attacks, the vituperative rhetoric, the name-calling, the takeover of the Justice Department, which for time immemorial, one of the pillars of our constitutional system, even though it's not written into the Constitution, you know, there are a lot of norms that have come into play over these 250 years that are very important, one of which is the independence, not just of the judiciary, but the independence of the Department of Justice from the White House. These are structural strengths in our system. And so, yes, the attack by this administration on the judiciary as a whole, on individual judges, the name calling, the purposeful, willful, intentional undermining of the rule of law itself is very dangerous, inimical to constitutional democracy. And I hope that with our voices as the Article 3 coalition, with the voices of so many law firms and law organizations and other civic-minded organizations, I hope this will stop and will return to a time when each branch of government showed the respect that was due it from all the others.
June, I just have one other thought. The vicious language that's been used against judges who've ruled in a way the administration doesn't like has to be understood as to its impact. It's not a question of the judge's feelings are hurt. We don't care about feelings when we're judges. We're not embarrassed to be criticized. We're criticized all the time. It's part of the job. We know that. We understand that. But the problem now is that when the president or the attorney general makes these vituperative attacks in social media, that thousands of deranged, fanatical, unstable individuals out there in the blogosphere may take it into their mind that they have to save the country by going to get rid of Judge Michel or Judge Davis because they've ruled in a way the president says is terrible. So now the attacks on judges are coming from strangers. You can't even identify who it might be. In the old days, it was usually a losing litigant who was upset with the judge. So the Marshal Service could better protect us because they could see who the source of the threat was coming from. Now they have no way of knowing or predicting. It makes it much harder for the very able Marshal Service to effectively protect judges. So this is a grave threat to the functioning of our democracy. Because if judges are terrified, no matter how brave they are, there's a danger that subconsciously it could influence their rulings and make them, so to speak, pull punches for fear of being the target of some deranged person who would try to kill them or harass their family or whatever. So it's not a question of hurt feelings from sharp criticism. It's a question of actual incitement to violence.
And the Marshals Service is fielding more online threats to judges than ever before. Thank you both so much for joining me today. That's Judge Paul Michel, formerly of the Federal Circuit Court of Appeals, and Judge Andre Davis, formerly of the Fourth Circuit Court of Appeals. They're both part of the Keep Our Republic's Article 3 coalition.
State of Utah versus Tyler James Robinson. Could you state your name?
Tyler James Robinson.
22-year-old Tyler Robinson appeared in court for the first time on Tuesday, facing aggravated murder charges as prosecutors seek the death penalty against him for the fatal shooting of conservative activist Charlie Kirk. Utah County Attorney Jeff Gray explained the aggravating factors in his decision to pursue the death penalty.
The state is further alleging aggravating factors on counts 1 and 2 because the defendant is believed to have targeted Charlie Kirk based on Charlie Kirk's political expression and did so knowing that children were present and would witness the homicide.
Robinson is charged with 7 counts in all. Joining me is Bloomberg legal reporter Madlin Mekelburg. Madlin, tell us about this first appearance by Robinson.
Tyler Robinson came before a judge for the first time this week, and it was a virtual appearance in a courtroom, which is pretty standard apparently for criminal cases in Utah County, where he was charged. And he appeared via Zoom from the jail, and the judge who will be presiding over the criminal case moving forward read the charges allowed to him, informed him that there was a possible sentence of the death penalty associated with those charges, and he asked him if he had an attorney yet. And he does not have a lawyer for him yet. The judge said based on his financial status, one will be appointed for him, and that's something that we can expect to happen in the next few weeks here.
And from what I understand, it has to be an attorney that's Rule A qualified, meaning an attorney who's qualified to deal with capital cases. So that limits the attorneys available. Did Robinson enter a plea?
No, we're not going to see him enter a plea for at least a few weeks. The way that things work in Utah, the next hearing is also going to be virtual, meaning that Robinson will be zooming in from the courthouse, and they'll be discussing whether or not he wants to waive his right to a preliminary hearing. This is a hearing where they would talk about whether there's enough validity to the charges to move forward to an arraignment, which would be yet another hearing where he would actually enter a plea to the charges before him. So we've a long road to go before we get there.
And from what authorities have said, he has not made a confession and he's not talking to investigators.
So Utah County Attorney Jeff Gray has been the public face of the prosecution so far, and he's really declined to weigh in on exactly how much Robinson may or may not be cooperating with investigators. But we heard previously from law enforcement authorities that he has not been cooperative with them. There's no evidence so far that he's given them any kind of confession or admitted to anything. Although I'm sure you saw prosecutors released a ton of evidence that they say they have against him, which include text messages where he's talking about the shooting. But they declined to say whether they construe those as being a confession. And at this point, we have no reason to believe that he's confessed to authorities or that he's even cooperating with them.
Let's talk a little bit about those text messages to his roommate and why prosecutors are highlighting them.
So while he may not be cooperating with them, it's very clear that his family and people close to him are, or at least have been, providing law enforcement with information regarding their communications with him leading up to the shooting and following the shooting. Now, prosecutors say that he was in a romantic relationship with his roommate and that when he was on campus allegedly committing this act, he sent a message to his roommate telling them to look under his keyboard of his computer. And when the roommate checked under the keyboard, there was a note there that said, quote, "I had the opportunity to take out Charlie Kirk and I'm going to take it." And what followed is a series of messages that are allegedly between the roommate and Robinson. You know, the roommate is expressing confusion, shock, saying, "You're joking, right?" And Robinson apparently said to them, "I'm not joking. The roommate says, "You weren't the one who did this, right?" Robinson says, "I am. I'm sorry." And they go back and forth in this exchange, and Robinson apparently is talking about how he attempted to hide his rifle, how police arrested somebody at the shooting who was not him. I'm sure you remember those hours afterwards when police kept saying they had someone in custody, but they were not the suspect in this case. So I think the messages are significant because it clearly shows that Robinson was talking about doing this and explaining some of his thought process behind it, which is that he said, quote, "I had enough of his hatred," talking about Kirk.
Prosecutors didn't out and out state a motive, did they? I mean, I know that Gray had said Robinson was becoming more pro-gay and trans rights oriented, but did they explicitly say, here's the motive?
No, so they talked about the political elements of the situation here, but they have said that they're not talking about a motive at this point. They're only talking about the evidence that they have, which seems to include statements from Robinson's mother, who's the one who told investigators that in recent years her son had become more politically engaged with some of these left-leaning causes and more pro-gay and trans rights focused. That's something that was in the charging documents that came forward. And that seems to be significant because his family said that they identify as being more conservative voters.
His parents turned him in, right?
So when they discovered and identified in the images that law enforcement released that the shooter resembled their son, apparently they had some phone call conversations with him, had him come back to the house, and they spoke with a family friend who is a retired law enforcement official. And together they encouraged him to turn himself in to local authorities where he's from, which is about 4 hours away from where the university is where Kirk was speaking when he was shot.
And prosecutors have some physical evidence, DNA evidence?
Right. So prosecutors say that they have DNA from the trigger of the rifle that they believe was used in the shooting and the towel that the rifle was found wrapped in when they recovered it from the scene. They say the DNA they collected there matches Robinson.
And what about his conversations on Discord? The FBI director said that they're investigating the people who were involved in those conversations.
Apparently, Robinson was having conversations on Discord, which is a popular chat application that's used for people who play and stream video games, is my understanding of it. But apparently he was having a conversation with a group of friends and making jokes about the shooting and connecting himself to it without admitting anything. And those conversations have been discussed by, as you say, the FBI director and some officials publicly, but they're not actually mentioned in the charging documents that we saw filed from prosecutors. So we have to assume that'll be part of the evidence that they present against him at some point, but it hasn't been part of this initial charging.
Do authorities consider him a sole actor here, or are they looking for accomplices?
So at this point, prosecutors and law enforcement say that they are continuing investigating. They're leaving no stone unturned, but they've declined to answer questions of whether they believe he acted alone or this was a coordinated attempt. And so at this point, nobody else has been named as a suspect or even as somebody who has contributed to this in a different way. And so the investigation continues. It's possible that we see future charges against another individual, but at this point, there's no evidence to suggest that they have somebody else in mind.
Before Robinson was even arrested, Utah's governor said they would pursue the death penalty. But why did the prosecutors say he decided to seek the death penalty?
So there's been a lot of talk about this. The Utah governor came out and said that he was planning to pursue it. President Trump has said you need to pursue the death penalty. And when we heard from the county attorney this week, he said he made this decision independent of any outside influence, and that while he spoke with both the governor and the president, at least representatives for their respective administrations, he said he didn't receive pressure from them to make that decision, and they didn't raise it with him. So he's wanting to be clear that this is something he's pursuing based on the evidence that he has. And part of that is this idea that when the shooting occurred, there were children present, and there was also a risk of injury to other people that were there. So it wasn't a straightforward murder situation where it was just between two individuals. He was firing a shot across a crowd of people, and there was risk of injury to others who were there.
Did the prosecutors say where the political element of this fits in? Is he considering that this shooting was politically motivated?
Prosecutors noted in the charging documents that Robinson intentionally selected Kirk because of his perception regarding Kirk's political expression. So that's the mention that we've seen from prosecutors in the formal court documents, that he was motivated by the political expression. But they haven't declared that as the official motive, but they've noted that that was part of why Robinson allegedly decided to shoot Kirk.
About half the states have the death penalty on the books. When was the last time Utah used it?
So Utah is one of 23 states in the U.S. that currently allows for the death penalty to be imposed on an individual. Compared to other states, they have had less executions. Typically, when you're talking about the modern era of the death penalty, we look at executions since 1976, which was when the Supreme Court said that it is legal as a form of sentencing. And so since then, Utah has executed 8 people.
And what's the method of execution in Utah?
So Utah, like most states, every state that allows for the death penalty, their primary means of administering it is through lethal injection. But Utah is unique in that it's one of just 5 states that allows for a firing squad to be used in executions, but that's only in the situation where the state can't acquire the drugs that are required for lethal injection.
The last time the firing squad was used was in 2010, not so long ago. Are the feds also considering bringing charges against Robinson?
I think that's certainly a possibility. We've heard people in the Trump administration say that that's something that they're looking at. Prosecutors in Utah County declined to answer questions about that as well. They said that's a decision that's totally up to the federal government if they have charges that they want to pursue at a federal level. Nothing's been filed yet, but, that's always possible.
And Madlin, you recently went to the campus where the shooting occurred. Tell us what it's like there now.
That's right. So campus has been closed since the shooting, but it reopened yesterday. Classes resumed. And so there were multiple memorial sites set up at the university, and they were encouraging members of the public and students to leave offerings and to have a moment of silence at the site of the shooting, if that's something that was meaningful for them. I spent a few hours there in the evening before classes resumed, and then again on Wednesday morning. And the mood was the same both days I was there. It was very somber, very quiet. People were incredibly emotional, and they were passing through, leaving flowers, reading signs. There was chalk left out, and people had scrawled different messages on the sidewalks, on the roadways, and even on the side of some buildings, expressing support for Charlie and expressing, mournful feelings, but also hopeful feelings for the future, and saying things along the lines of, this didn't happen in vain, your mission is going to continue. And people who visited the amphitheater area where Kirk was actually shot, the university had placed these metal barriers preventing people from walking in, but many people came and leaned against the edge of them and just kind of were reflecting silently as they looked on this area. But a few passing through would stop and turn and look back up towards the building, which you can see from there where the suspect allegedly fired from. So there was a lot of interest, but most of it was coming from a place of mourning and wanting to find community and returning to the scene.
The next hearing is on September 29th. We'll see if we learn more then. Thanks so much, Madlin. That's Bloomberg legal reporter Madlin Mekelburg.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.